Okay, sir. Very good morning, everyone. It is my great honor to welcome you all to the last day of the 1 week online capacity building program on the changing dimensions of human rights in India, held from September 2nd to 8th, 2024. My name is Pooja Lakshmi, and I am currently pursuing LLM at Gujarat National Law University and serving as a senior associate at Pro Bono, India. It is my pleasure to introduce our esteemed speaker for the day, Manik Mahey, advocate at the Supreme Court of India and the High Courts of Jammu, Kashmir and Ladakh. Sir will be discussing on emerging trends of artificial intelligence, technology and its intersection with human rights. And with a remarkable decade of experience at the bar, Sir has built an impressive career, primarily practicing in the Supreme Court of India and the High Courts of Jammu and Kashmir and Ladakh. Sir's expertise extends to representing clients before High Court in Delhi, subordinate courts in Jammu and Kashmir, and Delhi as well, in the High Court in Patna and Meghalaya. Manik sir's current practice focuses on civil and commercial litigation with a deep specialization in infrastructure arbitration, and sir has provided legal assistance to numerous government and autonomous bodies, including the Sher-e-Kashmir University of Agricultural Science and Technology and Baba Ghulam Shah Badshah University. Sir also leads the panel council for the Indian Institute of Management in Jammu. In addition to his role as a standing counsel, Sir has successfully represented the government of Jammu and Kashmir in various courts and arbitral tribunals, and his experience includes working as a principal associate in a boutique law firm and serving as independent counsel for major corporates such as ITC Limited, Dr. Reddy's Laboratories, Max Life Insurance Company Limited, Sissel Pharmaceuticals, and many more. We are honored to have Sir with us today to share his insights on the involving intersection of AI technology and human rights. Over to you, sir.
Thank you so much, Miss Lakshmi, for the worthy introduction. I welcome all of you on this Sunday morning for this lecture, which I hope to be enlightening and insightful for all of you. And I would also like to express my gratitude towards Kashmir Law College and Pro Bono India, with special mention to Dr. Gupta and Dr. Gupta, both, for having me here. As you all know that we have gathered here to discuss the emerging trends of AI and their intersection with human rights. It's centuries of human rights development and brings us to the cutting edge of AI technology. We will also explore how long-standing principles of human dignity and freedom intersect with the capabilities and challenge which are posed by the modern AI systems. In order to categorize this bit and put a concise review on the subject, I will be categorizing this lecture into 6 key areas. Number one is the artificial intelligence and brief overview of AI technologies. Then we will move on to very briefly discuss the evolution of the concept of human rights, since you have already heard a lot about it in the ongoing lecture series. So we will just touch it and have a very brief introduction of it so that we can bridge it with the further discussion. Thereafter, we will move on to the privacy aspect of the human rights with particular mention to the right to privacy. Then we will move on to discuss the impact of AI, both positive and negative, on the human rights. Thereafter, we shall move to discuss the right to privacy amid the Indian legal framework. And then finally, we'll conclude with discussing the comments or suggestions or, putting on our ideas towards balancing AI with the human rights. So, in order to start, let's understand what AI or artificial intelligence generally means. So, in the most simpler terms, as defined by the Oxford Dictionary, it means the theory and capability of computer systems to be able to perform tasks which normally require human intelligence. Now, these processes would include visual perception, speech recognition, decision making, translations in real time, and so on. We also know that these days all the major tech giants have their virtual assistants or AI bots. Like Google has recently introduced Gemini, which is their AI assistant. Earlier, it was called as Bard. We all know that Microsoft has ChatGPT and OpenAI, which is fairly popular. Apple has Bixby, Apple has Siri, Samsung has Bixby, and so on. So to move further now, as legal professionals, I think we stand at the crossroads of technological innovation and the fundamental rights that form the bedrock of every modern society. Our world these days is changing at an unprecedented pace, driven by advances in artificial intelligence that were once the stuff of science fiction. Today, AI systems are making decisions that affect our lives in countless ways, from the content that we see online to the opportunities that we are offered day in and day out, and even the way the justice is administered in some scenarios. So as guardians of the law, I think it is very crucial for all of us to understand these changes and especially their implications on the human rights. So, to move further, let us discuss the recent advancements in the AI scenario. Uh, I have categorized five main technologies of AI that have been seen taking over our world these days. So, in the broader sense, AI refers to systems or machines that mimic human intelligence, as already told, to perform tasks and can also improve themselves based on the data or the information that they collect. The field of AI therefore encompasses various fields, which as I said, I have divided into five major heads. So number one is the machine learning. Machine learning is the subset of AI that focuses on the development of algorithms that can learn from and make predictions based on the data or information that is already available. Then comes the deep learning, number two. Deep learning is a subset of machine learning based on artificial neural networks with multiple layers. Deep learning has been particularly successful in areas like image and speech recognition. So all of us must have recently heard this buzzword deep fake, wherein we see the images of celebrities are being masked on the videos, and also audio samples or voices of some old singers are being masked on the recent audio tracks. That is done with the help of deep learning technology only. Thereafter, the third technology is the natural language processing, which is also referred to as NLP. This field focuses on the interaction between computers and humans using natural languages, enabling machines to understand, interpret, and generate human language. So, for example, we see that there are a lot of apps today whereby we use our phone camera to scan a text which is in a language that is unknown to us, and then it converts it into English or any other desired language in no time. That is done with the help of NLP. Thereafter, the other technology is the computer vision. This area deals with how computers can gain high level understanding from digital images or videos, essentially giving machines the ability to see, to not just see, but also interpret visual information. Uh, I will take a pause. Am I audible to all of you?
Yes, you're audible. Yeah.
Okay. Okay, so the last of this technology is the robotics. While not all robots use AI, the integration of AI into robotics has led to significant advancements in autonomous systems and human robot interactions. For example, a very crude example of this would be this self-cleaning machine, which is introduced by various companies, including Eureka Forbes. So you have this robot which is a small kind of machine which you put on your room, and it will automatically detect whole of the surface area and first mop it, and then get your floor cleaned. That also uses the AI robotics. Then the advancements of AI have led to their application across a wide range of sectors, as we all know. Number of one of which could be healthcare. We see that AI is used by a lot of these pharma giants to diagnose and predict diseases in prior. Thereafter, it is also been seeing in drug discovery and development. We also see that AI is being at least there are efforts to use AI for generating personalized treatment plans for the patients. Then thereafter, the other sector where AI is taking over is the finance sector. So algorithm trading is a important aspect where it is being used. So based on the data available, AI can suggest you the stocks that you should buy or you should sell. Then there are fraud detection measures also, which are taken by the help of AI. Then AI also generates personalized portfolios for trading and investment, giving the personalized financial advice to the clients. Therefore, the other significant aspect is the transportation. We all have heard about Tesla and how Tesla makes the autonomous vehicles. So that technology is obviously driven by the AI. We also see these days that a lot of Indian vehicles also come equipped with this technology called ADAS, which adapts to the roads and makes your vehicle partially autonomous. That is also being driven by AI. Thereafter, the traffic management systems are being facilitated by the use of AI. And then there is predictive maintenance for vehicles and infrastructural measures that AI has been taking in the transportation sector. And then in the education sector, we see that personalized learning platforms are being created, automatic grading systems are done, intelligent tutoring systems, which help create customized plans for the students based upon their aptitude. Then the other important use of AI has been seen in the field of law enforcement and security. It has been seen used in predictive policing. Then we know that facial recognition and surveillance is something where AI has taken over, and there has been a lot of debate over it also. Then it also aids in detecting cybersecurity threats in a lot of cases. Thereafter comes the customer service. So number one example in the customer service would be the chatbots and virtual assistants. So you see that a lot of apps these days, including, let us take the example of Zomato and Swiggy. When you have a grievance against them, you go to the customer care option and you see that immediately a chat window is popped out where you are able to narrate your problem to the virtual assistants. And sometimes it is also solved in real time by those virtual assistants also. So that is one other example, where AI bots and virtual assistants are used in the arena of customer service. Thereafter, a lot of personalized recommendations are also created for the companies to woo customers for buying their products. Then there is the sentiment analysis for customer feedback. So sentiment analysis would mean that AI would in real time track your feedback and see how the behavior, with the help of the tools, your through your device. They will collect your data, and then they will generate a kind of feedback to serve you better in future, the companies. Thereafter, there is another aspect where AI has been, seen to be a very useful tool. That is the environmental protection. So it has been seen that AI has been aiding in climate modeling and prediction, wildlife conservation through image recognition, and also most importantly, optimization of energy consumption in the bigger cities, which are, now also termed as the smart cities. So these applications demonstrate that transformative potential of AI across various aspects of our lives is significant. However, they also raise questions about privacy, accountability, and the potential bias for the discrimination. So in this lecture, we are now primarily going to focus on the privacy aspect of human rights, because it is an arena which is thoroughly vulnerable of being impeded by AI systems and their ancillary processes. This further being a global concern globally needs exclusive attention for obviously. And then, uh, however, uh, before discussing the right to privacy, we will discuss very briefly the evolution of concept of human rights and also the relevant provisions of UDHR and EU Charter of Fundamental Rights, which are considered to be global milestones in giving human rights their true color and flavor. So, beginning with the evolution of human rights, very briefly, this concept has evolved over centuries, but its modern formulations emerge primarily from two pivotal periods of history. That is the Enlightenment era of the 17th and 18th century and the aftermath of the World War II. So the Enlightenment era is often called as the age of reason also, as it saw philosophers like John Locke, Jean Rousseau, and Immanuel Kant articulate the ideas about individual liberty, equality, social justice, social contract. Locke, for instance, argued for the natural rights of life, liberty, and property, concepts that would later on influence many human rights declarations. These ideas did not just thereafter remain in the realm of philosophy. They also played a very crucial role in shaping political revolutions, most notably the American Revolution of 1776 and the French Revolution of 1789. Then thereafter, there were the post-World War II developments. The horrors of the World War II, particularly the Holocaust, brought a renewed focus on human rights on a global scale. The establishment of United Nations in 1945 therefore marked a turning point with the international community to prevent such atrocities to happen ever again in future. The commitment, therefore, as we all know, culminated into the UDHR, which is the Universal Declaration of Human Rights in 1948. UDHR obviously is considered to be a very important document, rather a milestone event that for the first time set out fundamental human rights to be universally protected. The UDHR, now we will discuss in a little detailed later, so far as their applicability in the right to privacy is concerned. But before that, let us focus on the background that led to the UDHR. So it was adopted by the United Nations General Assembly, as many of us would know, on December 10, 1948, in the aftermath of World War II, as the international community sought to articulate a comprehensive set of rights to which all human beings should be entitled, and that's how it came to be in force. Drafted by representatives from diverse legal and cultural background, the UDHR was proclaimed as a common standard for achievement for all people and all nations. It's also important to note that while the UDHR isn't a legally binding document, it has inspired numerous international treaties, constitutions, and laws time and again. The UDHR primarily consists of 30 articles covering a wide range of human rights. Then the other important document that led to shaping of the human rights scenario throughout the world is the European Charter of Fundamental Rights. So while it is not directly applicable in India, the Charter of Human Rights, which was proclaimed in 2000 and made legally binding in the year 2009, is worth examining a little. It represents one of the most modern and comprehensive approaches towards human rights, particularly in relation to technological advancements. The charter applies to EU institutions and bodies and to the national governments when they are implementing the EU laws. Its influence, however, has been seen to extend beyond borders, often setting global standards for human rights protection in the digital age. So, as we discuss the background, now I think we must proceed to discuss the right to privacy. Uh, so, as we transition to discuss the right to privacy, we find ourselves at the heart of many contemporary debates surrounding, human rights and AI. privacy once was concerned only with physical spaces and tangible documents, but now it has taken an altogether new dimension in the present digital age. So let us explore how this right has evolved over the years and why it is so crucial to discuss the right to privacy, especially in the context of AI. So, first of all, the historical development of AI can be categorized into three periods. Very briefly. So, in ancient civilizations, many cultures recognize some form of privacy, often tied to ideas of personal liberty or sacred spaces. Thereafter, in the 17th, 18th century, Enlightenment thinkers began to articulate ideas about personal autonomy and the private sphere, laying groundwork for privacy rights. But the most important era in the realm of privacy is the late 19th century. So, in the 19th century, two legal scholars, namely Mr. Samuel Warren and Mr. Louis Brandeis, published a book called The Right to Privacy uh, in the year 1890 in the Harvard Law Review. So, which also introduced famously, the right to be alone. So that's how the right to privacy was perceived, the right to be alone. Uh, this is often, credited with crystallizing the concept of privacy as the legal right in the modern era, as it was the first time that right to privacy actually did get a recognition. So now we see that right to privacy has legal recognition in various jurisdiction and how. So in the United States, while the US Constitution not explicitly mentions the right to privacy, but it has been interpreted as part of several constitutional amendments, particularly the Fourth Amendment, which is very famous as it provides protection against unreasonable searches and seizures. Thereafter, in Europe, many countries, have strong protection for privacy. Talking about the European countries, particularly, the European Convention of Human Rights of 1950 explicitly protects the right to respect for private life and family life. Thereafter, in India, there is a famous judgment, which is a landmark judgment, with regard to privacy scenario in the Indian legal setup. This judgment is titled as Justice K.S. Puttaswamy versus Union of India, which established the right to privacy in India. And the court had, for the first time, the nine judges bench rather unanimously had said that right to privacy is intrinsic to freedom and personal liberty under Article 21, hence making right to privacy and as a fundamental right. We will discuss this judgment in detail in the later part of this lecture. So now we move on to discuss the relevant articles of privacy and technology across, the different declarations. Number one is the Article 7 of UDHR. It echoes, in protecting the right to private life and family life, home and communications. Then there comes the Article 8, which specifically enshrines the protection of personal data as a fundamental right. It states that personal data must be processed fairly for specified purposes and on the basis of consent or some other legitimate basis laid down by law. This article has been pivotal in shaping EU data protection laws, including the famous GDPR. So those who do not know what GDPR is, GDPR stands for General Data Protection Legislation. It is a EU law, the European Union law that was made applicable on 25th of May 2018. It is known to be one of the most comprehensive and also the toughest legislation on privacy laws. GDPR governs the way in which we use, process, and store personal data. It applies to all organizations within the EU, as well as those supplying goods or services to the EU or monitoring the EU citizens. Then thereafter, we go on to discuss the Article 21, which prohibits discrimination on ground, including on any ground, including genetic features. This is particularly relevant when we talk about AI systems that might process genetic data or make decisions based on protected characteristics. Thereafter, the last of the league is Article 38, which ensures a high level of consumer protections and also has implications for AI-driven market and decision making that affects consumers at large. So now these documents, the UDHR and the EU Charter, provide a framework for understanding as to how traditional human rights concepts apply in our rapidly evolving technological landscape. They emphasize the universality and inalienability, of the human rights. These principles, therefore, remain crucial as we navigate through the challenges posed by AI. So we will move on further to now discuss the privacy or the right to privacy in the human rights instruments across the globe. Again, we move on to the UDHR. The Article 12 of the UDHR says that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attack upon his honor and reputation. And it also says that everyone has the right to protection of the law against such interference or attacks. So therefore, the article lays the foundation for privacy as a universal human right. It's important to know that it protects against arbitrary interference, suggesting that some interferences might be justified if they are not arbitrary and are specifically enumerated or prescribed by the law. Then there comes the Article 17 of ICCPR, which is the International Covenant on Civil and Political Rights. Now, this article stretches the ambit of Article 12 of UDHR a little further. I will read out this article to you. Number one, it says that no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honor and reputation, just as the Article 12 of UDHR says. But it goes on further to say that everyone has the right to protection of the law against such interference and attacks. So ICCPR, doesn't only use the word arbitrary. It also uses the word unlawful, thereby further emphasizing that any interference with privacy must have a legal basis. So next we move on to discuss the evolution of privacy rights in the digital age. So essentially we are going to discuss as when we talk about right to privacy, what actually do we mean to protect here, right? So here are a few examples of the arenas which are which directly outflow from the right to privacy. Number one is the data protection. So with rise of the digital technology, privacy, we know, increasingly encompasses the protection of personal data. This has led to comprehensive data protection laws, as already discussed, like GDPR. Then there is informational self-discrimination. This concept was first articulated by a German court in the year 1983. It asserts that informational self-discrimination. So it asserts that individuals have the right to decide for themselves when and within what limits they want their information about their private lives to be communicated to others. Then the third is the right to be forgotten. Emerging from the EU law, again, this right allows individuals to request the deletion of their personal data under certain circumstances, reflecting the challenges or maintaining privacy in the era of persistent digital information. There comes surveillance and encryption. Issues of government surveillance and the right to use inscription have become central to privacy debates in the digital era across the globe, and there obviously is a global concern regarding this also. We all have heard about this software called Pegasus, which is used by a lot of governments to collect individual data and information without consent. So that's how this has a direct impact on our right to privacy, talking in the most layman terms. So now, as we move on into our discussion of AI, These evolving concepts, as discussed now, would be crucial. AI systems often rely on vast amounts of data, we know, raising obviously the questions about consent, data minimization, and the potential for privacy invasive surveillance. Moreover, as AI's ability to analyze and infer information from seemingly innocuous data challenges traditional notions of what constitutes to be a private information. For example, AI algorithms might be able to infer sensitive personal characteristics from public available data, blurring the lines between public and private information. One of example of such information could be the sexual orientation of a person, right? And then we move on to discuss our next heading, which is the AI's impact on human rights. So first, we will discuss the positive impacts, and then we shall go on to discuss the negative impacts. So the positive impacts would include the enhancing, of access to information and services. As we all know, AI can democratize access to information and services, potentially advancing rights such as the right to education, right to health, and so on. AI-powered translation services can break down language barriers, as already discussed under the NLP, making information more accessible globally. Virtual assistants and chatbots can provide 24/7 access to basic information on healthcare and education, especially in the unreserved areas. Then it can be used to improving healthcare and education also. uh, in healthcare, AI can assist in, as we have discussed, that it has already been done, that AI can assist further in early detection of diseases amongst, patients, generating personalized treatment plans for them, and also aiding in the drug discovery for the ailments, which may impact, or result into saving millions of lives. In education, AI-driven personalized systems or learning platforms can adapt to individual student needs, potentially making quality of education more accessible and effective. Then AI can also help in enhancing transparency and accountability. This is particularly relevant in the government setups, as AI can analyze large data sets to detect patterns of fraud or misconduct in government or corporate activities. Then it can also, through the machine learning algorithms, analyze vast amounts of public records, making it easier for citizens and watchdogs to, hold authorities accountable. Then supporting the environmental causes. AI models can improve climate predictions and help in developing more effective strategies for combating climate change. AI can also optimize resources used in agriculture and industry, potentially, therefore, reducing the environmental declaration. So now these are a few of the positive impacts or suggestions as to how AI can be utilized for positive outcomes. Now we move on to discuss the negative impact or challenges and potential violations that AI may cause. So number one is and the most important amongst all is the privacy and data protection concerns. So as systems often rely on vast amounts of personal data, raising questions about consent, data minimization, and purpose limitation, they pose a great threat to the individual privacy and information. Uh, then there is, AI's ability to infer sensitive information from, innocuous data challenges. For instance, AI can predict health conditions, as already said, or sexual orientation of a person from the social media activity. Then AI-powered surveillance systems, including facial recognition technology, can enable unprecedented levels of monitoring, potentially, creating a chilling effect on freedom of expression and assembly. Algorithmic bias and discrimination, is another threat. The opacity of decision making is also something that needs to be looked on, as the complexity of some AI algorithms can make it difficult to understand or challenge their decisions, potentially, violating the due process rights. Uh, then the other aspect is impact on freedom and freedom of expression and information. So uh, AI definitely impacts on freedom of expression and information, as we might have understood from the discussion today. Content moderation is something, which is a deep cause. So AI-driven content moderation on social media platforms might inadvertently censor legitimate speech. Then there is deep fakes and misinformation, as already discussed. AI's ability to generate realistic fake content, which obviously poses challenges to the integrity of information ecosystems. Then there is the other growing concern, that is the right to work. The increasing automation of AI-enabled systems has greatly impacted, caused speculations about the right to work. People are worried about the job displacements, as AI and automation, might lead to significant job losses in certain sectors, potentially impacting economic rights. Then changing nature of work, AI fundamentally changed the nature of many jobs, requiring new skills and potentially, creating economic inequalities amongst the various societies. Thereafter is the right to human dignity and autonomy. Um, when AI systems make important decisions about individuals based on the data, of course, it may challenge the right to have significant decisions made by the human. AI systems can also manipulate, data. The AI-powered techniques might be used to influence behavior in ways that undermine individual autonomy. These challenges underscore the need for, human rights-based approach to AI development and deployment. We, all of us, together as a society, need to ensure that AI technologies are designed and used in ways that respect and promote human rights rather than undermining them. So now we get to the most important leg of this lecture, which is the right to privacy in the Indian legal framework. As we narrow our focus to the Indian context, we find ourselves at a critical juncture. India, with its rapidly growing digital economy and large population, stands to be significantly impacted by AI technologies. Now, let us examine the current legal and policy framework as it relates to AI privacy and human rights. So, the most important turning point in the Indian legal framework is the judgment of K.S. Puttaswamy versus Union of India. In the year 2012, a batch of petitions were filed challenging the Aadhaar scheme introduced by the government in 2009, as it aimed to collect demographic and biometric data. It was contended that collection of these information directly impact the right to privacy. These petitions were led by the petition of Justice K.S. Puttaswamy, who happens to be a retired High Court judge from the Karnataka High Court. When the hearing began, it was heard by the bench of three Supreme Court judges. It was argued that these the moves of the government are impacting the right to privacy, as they aim to seek and collect personal information, particularly the demographic and biometric information of the citizens. So uh, it was also contended that right to privacy is intrinsic to right to life and personal liberty, and under Article 21, and hence it should be protected. The Attorney General appearing for the state, on the other hand, argued that the right to privacy as a fundamental right was in doubt, as two important decisions of the Supreme Court of the year 1954 and 1964 had categorically held right to privacy as not being a fundamental right. So these cases were MP Sharma versus Satish Chandra, District Magistrate, Delhi, and Khadak Singh versus State of Uttar Pradesh. These were heard and decision were rendered by the in these cases by an 8-judge bench and a 6-judge bench, respectively. It was argued that since these judgments are binding on the current legal scenario, in the current legal scenario, they uh, right to privacy cannot be protected, and there is no constitutional protection against the right to privacy. So the court heard the arguments, and the court was of the opinion, and thereafter, since it was heard by a 3-judge bench earlier, and since there were decisions against right to privacy by the larger benches, which were binding on the current bench, it was decided that the matter be referred to a constitutional bench of 9 judges. So initially, it was referred to a bench of 5 judges, but ultimately it landed up before the constitutional bench of 9 judges. And interestingly, in the judgment, the 9 judges unequivocally and unanimously said that right to privacy is intrinsic to right to life and personal liberty under Article 21. When it was argued by the state that right to privacy should be, there should be certain exceptions, the court said no. There cannot be there can be just exemption, but they have to pass the test of rationality. So in the Menka Gandhi versus Union of India, the court had said that under Article 21, the right to be fair, just and the right must be fair, just and reasonable, and not fanciful, oppressive, or arbitrary. So this was the test of rationality, which was introduced and coined in the Menka Gandhi judgment. The court reiterated that principle and said that no, right to privacy is intrinsic to the right to personal liberty and right to life and personal liberty, and under Article 21, and hence making it a fundamental right. The court also said that it includes the right to privacy, includes the preservation of personal intimacy, sanctity of family life, marriage, procreation, the home, and also the sexual orientation. The court further said that informational privacy is a very important aspect or the facet of the right to privacy. It also observed interestingly, the contents of Article 12 of UDHR in the judgment. The court, however, said that the right to privacy cannot be completely absolute, and it is obviously subject to certain reasonable restrictions, though those restrictions must be reasonable. And then the court also recommended for a specific law or a legislation, for data protection in India. So there we know that there have been some of the legislation like the Information Technology Act of 2000, which had virtually become obsolete in dealing with the data protection challenges that we face today. So as a result of the recommendation of the court in the judgment of Justice K.S. Puttaswamy versus Union of India, Digital Personal Data Protection Act was introduced in the year 2023. So after the recommendation of the government, of the Supreme Court, the government appointed a committee of experts for data protection under the chairmanship of Justice B.N. Krishna. The committee submitted its report in July 2018 with the draft data protection bill. The bill evolved over the period of time, and ultimately it took the shape of DPDP Act, or the Digital Personal Data Protection Act, in the year 2023, which is still in the evolution stages. But this legislation is rather significant in the Indian legal framework because it comprehensively deals with the right to privacy and also the rights with regard to data protection, which has never been which was not there in the Indian legal context before. And to a lot of extents, it also imitates the principles that are laid down by the GDPR, which is a welcome development in our scenario. So to start and give you a brief overview, it introduces the act under section 2 introduces two terms, that is the data principal and the data fiduciary. So in the common parlance, data principal is the person or entity whose data is being utilized, and data fiduciary is the entity who is going to utilize the personal data of the data principal. So then this act goes on to create some rights and responsibilities, towards both data principals and data fiduciaries. So some of them, as we see, are the rights of the data principals. First, we will deal. So right of data principal include the right to information. So data principals can now request information about their personal data, which is being used to be processed. They also have the right to correction and erasure, which is very important. Data principals can request correction of inaccurate or misleading personal data, and can also request for erasure of their personal data that is no longer necessary for the purpose of which it was collected. Then there is a right to grievance addressal. Data principals can file complaints with data fiduciaries and escalate unresolved complaints with regard to data breach. And then these complaints can also be put to the data protection board, which we will discuss just later. Then the other right is right to nominate. Data principals can nominate another person to exercise their rights in the event of their death or incapacity in the future. So this intricacy is very important, and it tells us that uh, that how important it is to deal with the data, or the personal data that is available, that is right now easily accessible and available across the board. um, we then go on to discuss the obligations of the data fiduciaries. Yes, just a second. So data fiduciaries have the responsibility to implement reasonable security safeguards to prevent data breaches, including technical, organizational, and physical measures, notify the board and affected data principals in case of a personal data breach. They can also appoint they have to appoint a data protection officer for representing the data fiduciary and liaising with the data protection board. They have to conduct periodic audits to ensure compliance with the act. They have to publish notice of fair and reasonable summary of processing activities. Then there is a limitation on the cross-border transfers also. The act allows the cross-border transfer of personal data by the territory, but it also states that the foreign jurisdictions, which can use that data, will be notified from time to time. Then there are the penalties in case of breaches. The penalties against a data fiduciary can go up to rupees 250 crores in case of a significant breach. And then there are certain additional penalties also. So another important aspect of this act is the introduction of data protection board. Data protection board establishes, it is it aims to establish, it is still not in place, but the act aims to protect the data protection board of India. The members of this board will be this public servants within the definition of section 21 of the Indian Penal Code, and now section 2023 of the Bharatiya Nyaya Sanhita. The responsibilities of the board would include determining non-compliance, imposing penalties, monitoring and enforcing provisions, and it shall also have the powers of a civil court with regard to summoning and enforcing attendance of any person, receiving evidence, inspecting data, and all such powers of a civil court which are there can be exercised by these boards. These the In case of a complaint, in case of a grievance, and a data principal can or a data fiduciary can approach the board, and the board can investigate on the matter and give the decision. The decision can also be an appeal can also be filed against the decision within 60 days before the appellate tribunal, which is established under the telecom regulatory authority. Then there are certain exemptions also under the act. The exemptions are the national security, prevention, detection, investigation, and prosecution of offenses, collection of revenue, and so on. Then it also mandates, certain restrictions with regard to collection of children's data. It prohibits tracking or behavioral monitoring patterns of children and giving targeted advertising directed at children. It requires verifiable parental consent for processing children's data, and so on. So this is basically the brief overview of the DPDP Act. So now, as we run out of time, I will try to summarize, as much as I can, and I would move to the last leg of this lecture, which is balancing AI advancement and human rights protection. So, as we conclude our exploration of AI and human rights here, we face a crucial question as to how can we harness the transformative potential of AI while safeguarding the human rights. The balancing act is perhaps the most significant challenge that policymakers, technologies, and society at large is facing today. So some of these approaches could be the regulatory approaches, like right-based regulations, incorporating human rights impact assessments into AI development and deployment processes, ensuring that AI regulations align with the existing human rights frameworks, developing specific guidelines for AI specifications in sensitive areas like criminal justice, healthcare, employment, and so on. Then there is the risk-based regulation, categorizing AI systems based on their potential impact on human rights, imposing stricter regulations on AI on high-risk AI applications, regular assessment of risk categories of AI technologies, ensuring algorithmic transparency and accountability. Then ethical AI development, which means that developing and implementing ethical guidelines for AI research and development from time to time, promoting diverse and inclusive AI development teams to help identify potential biases and rights, human rights-centric AI, promoting AI systems that enhance human decision making rather than fully automating it, ensuring meaningful human oversight in critical AI applications, developing AI literacy programs to empower individuals in order to understand and interact with AI systems, responsible data practices, uh, as in they may include implementing strong data protection measures, including data minimization and purpose limitation, promoting the use of synthetic data and federated learning to reduce privacy risk, developing standards for anonymization and de-identification of data in AI systems. So these are basically the suggestive measures. Then we in order to make AI more effective and useful in the terms of human rights rather than being destructive, one thing that is imperative is the international cooperation. So developing global AI governance frameworks together, promoting international dialogue on AI governance, working towards global standards for AI ethics, addressing issues of cross-border data flows and AI development are some of them. Then knowledge sharing and capacity building, facilitating knowledge sharing between countries on AI governance practices, promoting global research collaborations on societal impact of AI, and also then working to bridge the AI divide to ensure that the benefits of AI are globally distributed, addressing concerns about AI-driven economic disruptions on the global scale, ensuring that AI governance systems consider the need and perspective of diverse societies, continuous evaluation and adaptation according to the growing needs, establishing mechanisms for ongoing monitoring and evaluation of AI impacts on human rights, regularly updating regulations and ethical guidelines to keep pace with the technological advancements, promoting interdisciplinary research on the long-term societal impacts of AI. And particularly in the Indian context, uh, balancing AI and human rights protection would present unique challenges and opportunities like leveraging AI for development, focusing on AI application that can address development challenges such as in healthcare and education, ensuring that AI development doesn't create social and economic equalities, data protection and localization, finalizing and implementing a robust data protection law that addresses AI specific challenges. Uh, one of such laws is already in place, as we discussed. We only have to see how it is being utilized in future. Then the other aspect is building AI literacy, developing programs to increase AI literacy among the general public, policymakers, technologists, legal professionals from time to time, including AI ethics into the technical education curriculum, promoting inclusive AI development, which means that ensuring that India's diverse linguistic and cultural landscape is reflected in AI development and it is not left out, then addressing potential biases in AI systems that could disadvantage certain groups. So, uh, having discussed this, since we ran out of time, I will try to conclude it. So this is a topic that is which is since evolving has a lot to include, and the debate can just go on and on. Though in order to now conclude, I would just say that it's clear that balancing AI advancements with human rights protection is a complex, ongoing challenge. It requires collaboration between technologists, policymakers, legal experts, and civil society also. So, by adopting a proactive, right-based approach towards AI governance, we can work towards a future where AI is enhanced rather where AI enhances rather undermining the human rights. So I would also like to urge all of us to ensure that our commitment towards the view of AI, that we do not just see AI as a challenge to human rights, but we see it as a potential tool for advancement of the human rights with thoughtful regulation, ethical development, and a commitment towards human-centric AI. With this, I try to conclude my lecture. I hope it had provided you some sort of
Thank you, sir.
information into this subject. Thank you.
Thank you, sir. Dear participants, please put your questions on the chat box, and also please raise your hands if you want to be unmuted. So I got some questions in the WhatsApp. May I ask the same?
Yes, yes, please go on.
Sir, shall I start
Yes,
with
yes,
the
please.
questions of WhatsApp? Okay. So first question is, what's your opinion about the citizenship given to robot? Because most of the robots now are interlinked with the AI and used in a very great extent, and also a robot is given citizenship in Dubai, etc. So what is your opinion?
This is, as I said, this is still an evolving concept, and giving citizenship rights and complete autonomy to machines and robots is obviously something that can be alarming in future. And I think that, as already said in the lecture also, that we must not facilitate introduction of full autonomy amongst the AI technologies, for example, robots. There has to be some form of governance, human governance on these aspects. Otherwise, we may not lead to a very, welcoming future. Thank you.
So another question is, what is the negative impact of AI in the agriculture?
Can you come again, please? Your voice is breaking.
Sir, what is the negative impact of AI in the agricultural sector?
See, negative impact. As I said, AI is still evolving, and we cannot categorize as of now what can be the negative impact of AI. But yes, if we start to use AI tools, to plow our fields, or facilitate agriculture mechanisms like putting in fertilizers and all, then obviously it is going to harm us. So as I said earlier, the bottom line remains that there has to be check on the AI technologies in order to facilitate the rights, or the human rights, instead of giving them full autonomy.
Whether AI will increase the disparity between marginalized community and others to get human rights resources and benefits.
See, it depends. It may or may not. It depends on how we use the AI technologies. If we use the technologies, within the legal framework, and with an objective of facilitating the human rights and inclusiveness, then it may act as a catalyst also. But in case we give unfettered powers to the AI systems and technologies, then they can go haywire also.
Thank Thank you, sir. Now I would like to invite Kalpesh sir for the vote of thanks.
Really, a second. We have Mr. Yak Ibrahim. Over to you. Yeah. Yes, Mr. Yak Ibrahim. Over to you. Yes. Hello.
Hello, sir.
Yeah, yeah.
I'm
Over to
audible?
you. Yeah, yeah.
Okay, sir. 1 second, sir. Uh,
Sir, you're audible.
yes, sir. Good afternoon, ladies and gentlemen. So, today was our last session of this 1 week capacity building program on human rights. So, first of all, I would like to thank our esteemed resource persons for their precious time and providing valuable insights about different dimensions of human rights. Our esteemed resource persons, through their vast experience and diverse knowledge, provided the vibrant and knowledgeable sessions to make this 1 week capacity building program on human rights a success. In this regard, our heartfelt thanks on behalf of Pro Bono India and Pro Bono Kashmir Law College go to Advocate Shri D.C. Rana ji from High Court of Jammu and Kashmir, Professor Dr. Kulwant Singh from Kashmir KC Law College Jammu, Advocate Karman Singh Johal from High Court of Jammu, Kashmir and Ladakh, Dr. Anish Pillai from Cochin University of Science and Technology, Kerala, Avani Verma from National Human Rights Commission, Dr. Priya Gupta from Jammu, and for today's vital session by Advocate Manik, Mahey, Advocate Supreme Court of India and High Court of Jammu, Kashmir and Ladakh. We are highly thankful to our dear participants for their patient learning in all these sessions throughout this 1 week capacity building program on human rights. The cooperation of our participants in this regard is highly solicited. After that, our organizing team is highly grateful to our mentor, Dr. Kalpesh Kumar Gupta sir, for encouraging us and guiding us every time regarding the conduct of these programs. Dr. Kalpesh sir has been a source of inspiration for all of us. You have been so cooperative and kind to us and have given us moral support at every level to hold this program. Thank you so much. And our team is highly thankful to Dr. Priya Gupta ma'am for her sincere and untiring efforts in the smooth conduct of this program. Lastly, I am thankful to Ms. Pooja Lakshmi from Gujarat National University, Ms. Sakshi and Ms. Nasreen Farooq for their hard work and dedication during this entire 1 week capacity building program. At the end, I am optimistic that we will remain connected with one another and come out with similar programs in near future to, to glow our societies with the radiance of legal education. With this, our 7 days capacity building program on human rights comes to an end. And now it's over to Dr. Kalpesh, sir.
Yeah, thank you very much, Mr. Yahya Ibrahim, and thank you very much, Mr. Manik, for your insightful session. I hope participants got some insight. Like, everybody, I think, especially law student, professional, they've studied, there's a paper, human rights in our law schools, or even you learn something in practice. But these are the emerging trend, coming up, has come up, and obviously a lot of things are happening in near future also. So we should be aware and what new things that we can do in this particular field. So before this close, we can have some oral feedback. Would like to any participant like to say something related to feedback? Obviously, we have floated feedback form. So any participant, you can unmute and yes, please. Any feedback? Yes, Miss Priya, like Dr. Priya, you like to say something? Like you organize entire thing, right? This time I ask you just prepare entire thing, prepare topic and the list of resource person that you did very well. Yes, please. Yes, Dr. Priya, are you there?
Yes,
Yeah,
I'm there.
please. Yeah, sure, sure. Yeah.
Yeah, I am just trying to put my camera on.
Okay.
So, if you would allow me. Uh, Camera is not on. Am I
No.
audible to all of you?
Yeah, please carry on.
Yeah, so first of all, as Mr. Yahya also, said in his vote of thanks, that I really, Professor Kalpesh, I'm really, really grateful for, coming up with such an idea. And when I say that, I really speak that from the bottom of my heart. Because, I think everybody in the audience would also agree with that the trend of studying law had become so obsolete in our regular law schools, and it was just confined to the books that we were reading, and just confined to the limited knowledge that the professors had, because now with the emerging trends, as we also have advocate Manik Mahey with us today, and he was speaking on the emerging trends of artificial intelligence, because as far as I remember, we have never studied this aspect of law while we were doing law. And even if we talk about the other subjects that were taken up in the 7 days, last 7 days, and if we talk about the other programs that you're already conducting, Professor Kalpesh, I think this is a wonderful idea to gather together. And first of all, it is not only limited to the students, it is limited to everybody who has a commonality of interest. It is welcome all the governmental, non-governmental organizations, and anybody in the audience can come up and just have an insight on various subjects. So I think this is a great initiative. And the best thing about it is that, all of us, even if we are sitting in our night suits at our home, we are just plugging in our AirPods and listening to the information that all the expertise, people are providing us with. So thank you so much for coming up with such an initiative. And this is what we need in the present scenario in a digital era. Thank you so much, Professor Kalpesh.
Yeah. Thank you very much, Dr. Priya. Any other participants? We have a few minutes. We will close.
Dr. Gupta, there is a question in the chat box by Miss Harshita MV. If you allow me, I would like to answer.
Please. Yeah. Closing. That's why I'm not taking. Yeah, over to you. Yeah.
Yes. So she's asking, does India need a new law to tackle AI issues like deepfakes, or the current legislation under IT laws itself enough to tackle the issue? So as I already stated that there is this new legislation called the Digital DPDP Act, which is set of 2023. The procedure is already in place, the framework is already in place, but this law will take some time to evolve and develop. And as it evolves, there will also be rules. And I'm sure there could be rules to address issues categorically like deep fakes in case such breaches and infringements appear to be on a higher scale in future. And I think that answers your question.
Sure, sir. Thank you very much. Any other participant?
Sir, good morning,
Good
sir.
morning. Yes, madam,
Manik,
over to
sir,
you.
good morning. Thanks a lot for a very
Very
insightful
good, very
session.
good morning, ma'am. Very good morning.
Sirji, it is like this ki we have not gone through all these things. And
Okay.
we have learned, we know human rights means what? We equal rights to everybody. है ना?
Right.
And now what is latest technology and all that, you have given a feast of knowledge to us. Really.
Madam,
Feast of.
I am,
sorry,
I
over
am,
to you.
I am highly grateful, ma'am, because despite all the blabber that we do in the courts, I am not very adept in delivering formal lectures. So in case I am able to give you at least a tad bit of insight, I am more than delighted.
Sirji, I was also in the same position, but then gradually I picked up and updated myself. Now
Madam,
I can speak.
Madam is a oldest participant of, she has been attending various programs, 76-year-old, 50-year
Oh,
experience.
all right.
So there is, Nalini ma'am, over to you.
All
Yes,
the
sir.
resourceful persons were
Thank
really
you.
very, very excellent sessions. They have given their deliberations because, we have not studied all these things, and now latest technology is adopting all these human rights and giving information. We were knowing that only Constitution has given some articles, 14, 21, like that, we have right to speak, democratic country, all these things only we were knowing. No, but now so much in detail, so it's very highly commendable for Kalpesh sir also to initiative and taking up all these sessions with everyone.
Thank you.
So
Thank you.
thanks a lot. God bless
Thank
everybody.
you.
Thank you so much, sir.
Thank you, ma'am.
Thank
Yes, Nalini ma'am, over to you.
Yeah, I mean, I heartily agree with the participants who have just spoken before me, and I'm grateful to both to pro bono and to our esteemed speakers, and especially the speaker for today. The issues that have been raised are so real, so important, and I want to really, say that yes, why are they not being taught in law colleges? Why are law colleges not discussing this? And in this context, the recent discussion with Professor Shanta Kumar, where he himself said that we should teach less and discuss more, even in the classrooms and so on. That is really so important. And here, even for example, I'm concerned with the right to education. And I was so shocked that it's a fundamental right, the only fundamental right that has been added to the Constitution after it was adopted. Even that is not being taught in the law schools. Then how on earth will a lawyer recognize a violation of the right to education? The similar things are happening over here, even with all the other human rights. And when I looked at what is happening, one of my friends, he filed a case against the Bar Council and recently got an order also for it to be implemented. How it will be implemented, now let us see. But the similar situation is there for legal rights and all of these human rights, especially the rights of women and children. These are rights which are not taught in the Bar Council curriculums, which are focused more on the needs of corporate institutions and not on the needs of societies. I'm sorry, I mean, maybe I'm being unfair to them. I don't know so much about it, but I know definitely that they're not teaching human rights, etc., in the compulsory curriculum. So to that extent, I feel that here is where we, as people who are concerned, ought to also uh, petition the law, the Bar Council. Also raise issues in court regarding what the Bar Council is causing to be taught in the colleges. If we think these are so important, and we thank, of course, Pro Bono India for bringing us together and raising these issues and, exposing us to them. So this is what I'd like to say. Thank you so much.
Yes, thank you very much, Nalini ma'am. So before this, we did 1 week capacity building program at to education. So that was a MEMS idea, right? I implemented with the in under the banner of Pro Bono club and now with support of Pro Bono India, right? So that was a great idea. We discussed with ma'am in March 2002 this year only. So that is a thing, and then same thing with human rights also. We planned this. Any other participants? Last word before we close. So whatever
हाँ
you
बेटे क्या बोला तूने?
Yeah. So a participant, like whatever you learned, right? Keep, if you're a teacher, you keep disseminating, discuss in classroom. Be a professional, start practicing this thing in various level where you are from, and maybe difficult for non law background people, right? I don't know how many from non law, but again, you've got good insight. It's not related to law, right? It's basic, right? That what we listening for last 1 week. So thank you very much for joining. So look forward to see you in future program also with some good topics. Thank you very much.
Thank you.